Testing 1, 2, 3. Paul, you better help me, dear. I can't get this on. It's not on. Hello?
Good morning, Judge Rovner. We're turning on the
Oh,
television
good.
here.
Good. Thank you. I was afraid that you were muted. Good morning to you both. Good morning, Judge Ripple. Good morning, Judge Brennan. And good morning to everyone in the courtroom, and welcome.
Good morning.
So, all right, we're going to get started. And our very first case for the day is appeal number 22-1199. And it's Yancheng Shanda Yongfeng Equity Investment Partners versus Kevin Wan. And it's Mr. Sokolov.
Good morning. Thank you, Your Honor.
Good morning.
May it please the
Good
Court.
morning.
My name is Eugene Sokolov, and I represent the appellant Kevin Wan in this matter. It was Yancheng's burden in this case at summary judgment to come forward with proof of subject matter jurisdiction. It never did that, and the affidavit it has submitted on appeal cannot solve that problem. This Court should vacate the judgment below and remand with instructions to dismiss. Yancheng is a partnership comprising 4 entities that it claims are Chinese citizens. The problem is that only individuals and corporations have their own citizenship for purposes of 1332. Other forms of unincorporated associations take the citizenships of their owners. And in this case, Yancheng's ultimate owners, the owners of its partners, include stateless entities that destroy complete diversity.
Well, if we were to,
Go ahead.
I just wondered if, though, isn't that the fundamental question in the case? If we can read 1332A4 in concert with 1332A2, we'd have diversity jurisdiction, right?
Your Honor, I don't think so. I think that there's the more fundamental problem that 1332A4 creates diversity jurisdiction in the case where a foreign state is a plaintiff. And in this case, the plaintiff is Yancheng, which doesn't even claim to be a foreign state and couldn't meet the requirements to qualify as a foreign state under 1603. As the Supreme Court explained in Dole versus Patrickson, the way to satisfy 1603, the way to qualify as a foreign state, is through direct majority ownership by a foreign sovereign. And there's no dispute here that Yancheng can't qualify. Now, it's true that the citizenship status of the partners of an unincorporated association, like Yancheng, are imputed to that association. So Yancheng, for example, if it had partners that were located in Illinois and California, would have dual citizenship of Illinois and California. But it doesn't take their form or their status. So while this court explained in Page, a partnership that has stateless partners is stateless and destroys complete diversity under 1332, the partnership does not become, for example, a corporation by virtue of the fact that a corporation is among its members, nor can it become a foreign state simply by virtue of the fact that there may be foreign states further up the chain. So that flows just from the text of 1603, which sets out what it means to be a foreign state. And the court, I don't think, needs to get into the question, which is unsettled as far as we can tell, whether it would be appropriate to use together A2 and A4 in a case to sort of cobble together a
Because of
jurisdiction.
the indirect ownership.
Because of the indirect ownership, exactly.
What, is this just a hole in our statutory scheme?
That's right, Your Honor. I think that's effectively what it is. When Congress revised 1332, when it enacted the Foreign Sovereign Immunities Act, it changed the language of the statute. It made clear that what remained in terms of federal diversity jurisdiction, obviously the parties here could seek relief in state courts, but what remained of federal diversity jurisdiction for a foreign state was when it acts as a plaintiff.
Well, what do you make of Judge Friendly's opinion in the Ruggiero case out of the Second Circuit?
I think what Judge Friendly was concerned there was what would the animating purpose of the changes that Congress wrought. And where he came down, I think, is perfectly consistent with our position, which is Congress intended to make clear that foreign states could both be plaintiffs in diversity and defendants subject to the
That's
protection.
where I have trouble. It seems
Yeah.
to me that it is contrary to the animating purpose, as Judge Friendly would have saw it, for us to say Congress left a hole here. Congress was terribly careful in making this adjustment. I just don't see how we can say Congress left a hole because of indirect ownership.
Your Honor, I would say,
Go ahead. I do have somewhat of a follow-up there, but go ahead.
so I think that Congress in effect left, I wouldn't call them holes, I would say that Congress crafted a new jurisdictional statute in the revised 1332 that differs in two ways that I think are relevant here. One is previous subsections 2 and 3 both featured foreign states. So you could have a foreign state on either side of an action. It could be in diversity under A2. You could also have a case between citizens of different states and have foreign states as additional parties to the action. In the revised post-FSIA version of the statute, you cannot have a foreign state as an additional party either. The only place it appears in 1332 now, the only place a foreign state appears in 1332 now is in A4, where it's acting as a plaintiff. And it may seem anomalous, but I think it's consistent with the court's reasoning in Page, which is to say that it matters who the parties are before the court. And in this case, we have a party that clearly cannot satisfy the statutory predicate for qualifying as a foreign state. And there's no reason, I think, to expand the plain text of the statute to let in a partnership, which is not a foreign state, which has foreign states only several, at least one and possibly more layers up the chain, take advantage of a statute that's not designed to fit that situation. But Judge Rovner, I don't.
Just let me make certain that I understand something. Are you contending that if there are multiple plaintiffs, and some are citizens or subjects of a foreign state, and some are foreign states, the plaintiffs can never establish diversity? Would they be forced into state court? I mean, how can that be if it is what you are arguing? How can that be what Congress intended in Section 1332?
So, Your Honor, I don't think that you need to reach that question here, because here you don't have multiple plaintiffs. You have one plaintiff, and that plaintiff clearly is not a foreign state. It merely includes owners further up the chain that may qualify as foreign states. And as the court held in Page, we impute the citizenship status of the partners of a partnership to the partnership. But I would say it's not so strange, because in other situations where, for example, you have an expatriate and a citizen of a U.S. state suing citizens of another state, the presence of an expatriate on one side of the lawsuit, a stateless person, destroys diversity jurisdiction even when they are individual parties. So,
Is there any real doubt that all of the relevant plaintiff entities are citizens of China? Are you resting? Are you resting solely on the lack of evidence in the record, or does the defendant have some evidence that a plaintiff entity in this case is a citizen of Illinois? What's happening?
So I think there are two ways that the court can resolve this case. One way, which is the way that it resolved the very similar situations in America's Best Inns and in the Guarantee National case, is to say, look, this plaintiff had a complaint, an amended complaint, summary judgment papers, an opening brief, and a jurisdictional statement in which it could have come forward with evidence that established a basis for diversity jurisdiction. It still hasn't done that. And in fact, the affidavit it submitted on appeal, not only is it not even clear if it's based on the personal knowledge of the declarant, a declarant who says that they are familiar with Yen Cheng, the partnership, and work for Yen Cheng, but doesn't explain how they could have personal knowledge of the details of the partners.
Couldn't we say the same, though, about your position? The other side has given us an affidavit that purports to substantiate its position that these corporations are, in fact, should be treated as corporations as opposed to limited liability corporations under our law. And we haven't heard from you in reply to that. I mean, haven't you had an adequate opportunity at this stage to rebut that affidavit and haven't done it?
Well, Your Honor, I guess I'm not sure I understand your question in the sense we have
Well,
certainly.
I've got a newer declaration from the other side, right, about corporation, substantiating their view on these corporations.
Well, to the extent
I haven't heard any rebuttal from you by way of affidavit on that issue.
So I would say, first of all, it's their burden, right, to prove subject matter jurisdiction. It's not our burden to rebut it. And to the extent that their affidavit includes a legal conclusion about the status, how these entities should be treated under U.S. law, we've certainly come forward with our arguments to explain why they should not. I mean, that's our
Is
entire.
this a question? Is that a question we can decide here? Is there any reason why we would send this back to a district court? The status of these Chinese corporations? Couldn't we resolve that here as a matter of law?
Your Honor, I think you could resolve the question here as a matter of law. I think that there are two issues at play. One of them is we don't have any information, any evidence to support the allegations in the complaint about who the ultimate owners of these entities are. So this is not a situation where the court could just say, well, let's assume that they're partnerships, but we can, and this goes to your question, Judge Rovner, when you said, is there any real dispute that these are all Chinese citizens? Well, there's certainly a dispute, right? The natural persons and the private entities here, we're not disputing they are Chinese citizens, although there's no evidence of that in the record, and it is their burden to come forward with evidence in summary judgment. With respect to the Chinese government entities, those are stateless, and so they do destroy diversity jurisdiction. That is a dispute between the parties. I think, Your Honor, Judge Ripple, just to answer your question about what's missing from the papers here for the court to make a decision as to whether these entities, these what they call limited liability companies, should instead be treated as corporations. It could take expert evidence to discern whether under Chinese law these are more like U.S. corporations. This is the question the court confronted in Fellows, right? In Fellows, and then later in Instep, a similar case involving similar types of entities. In Instep, the court said, we're going to send this back to the district court. The parties disagree about what kind of entities they are, and we need more factual development. In Fellows, the court said, well,
you would not be adverse, I take it, to a remand.
well, Your Honor, I don't think that there is any point in a remand. I think, in Guarantee National, I think the court put it very well that when a party has had an opportunity to make a submission on appeal, and that submission does not establish a factual basis for diversity jurisdiction, that gives rise to the inference that further attempts are not going to be successful either, and it gives rise to the inference that jurisdiction is in fact lacking.
Well, shouldn't the district court have an opportunity to sort out what are really complex and factual and legal issues about the citizenship of the plaintiff?
Your Honor, I think that some of these issues may...
None of this was brought to, you never... the district court never had the arguments that you're making now.
That's true, Your Honor, and that was also true both in America's Best Inns and in Guarantee National, a case where you were on the panel, Your Honor, where the question of whether there was sufficient information in the record to support subject matter jurisdiction didn't come up until oral argument. And after that, the court said, look, you need to file something that's going to reassure us that there's jurisdiction here. The parties did that, and the court was not satisfied either that in the America's Best Inns case, that the declarations that were submitted were made on personal knowledge, or that they supplied all of the necessary information, and the court said, that's it, you've had more than enough opportunities to meet your burden under the law, and there's no point in wasting everybody's time further. I mean, that in our position is that is the clearest analog to this situation, and the fact that it wasn't raised before the district court, well, it was raised in detail in our opening brief from pages 21 to 25. We raised all of these problems, including, sorry, Your Honor.
Oh, go ahead.
Including the fact that there was this question of whether foreign state status would destroy complete diversity here. And in the opposing brief, what did we get? We got an affidavit that doesn't even tell the court anything about the ultimate owners of these partner entities. And I think that strongly suggests that Yancheng understands it cannot show that those entities are not foreign states that would destroy diversity here.
Mr. Sokoloff, I'd like to get your view of Judge Easterbrook's opinion in the Bumatic case. He seems to take a very pragmatic view of when something is a foreign entity is a corporation for purposes of our jurisdictional statutes. What do you say about that?
Well, Your Honor, I think Judge Easterbrook, who, if I recall correctly, wrote both Bumatic and then Fellows, which is a case very much like this one, it all boils down to the same thing, which is that what matters in this kind of inquiry is the details. It's not enough, and I think this is clear from Bumatic, it's not enough that there be some features in common between the foreign entity that's bringing suit and a U.S. corporation, because after all, there are some features in common between limited liability companies and other forms of unincorporated associations that don't qualify as having their own citizenship and corporations. What matters is, what is the foreign entity more like? And in this case, the foreign entity is more like a U.S. LLC, something no one disputes wouldn't have its own citizenship. And since the other entities...
Why is it more like a United States LLC?
Well, for one thing, it imposes strict restrictions on the transfer of share interests in the companies. That's under the Article 71 of the Chinese law that Yancheng cites. That's something that both in White Pearl and in Fellows, the court said a key attribute of U.S. corporations is alienable shares. And according to the cases and the scholarship we cited in our brief, the requirement that Chinese law imposes of third-party consent before someone can alienate their shares, that is a hallmark of an LLC, not of a corporation. I would also say that Yancheng has not pointed you to a single case anywhere that has treated an entity like this as a corporation for jurisdictional purposes. And if you look at their brief, they cite three things. One of them is a complaint in the Merit Tat case, so that doesn't get us anywhere. The other two are decisions in which entities that are referred to as Chinese limited liability companies are referred to as corporations by the court, but where subject matter jurisdiction was not even in play. 1332 is not mentioned. There was no question of diversity or subject matter jurisdiction. So they've shown no case in which an entity like this counted as a corporation, and there are serious doubts on what they have introduced as to whether it could. I'm sorry, I see my time has elapsed, but thank you. Thank you.
Well, you've been answering our questions. So time flies when you're having fun, Mr. Sokoloff. All right, let's have Mr. Giovanetto. Morning.
Good morning. May it please the court, I'm Levi Giovanetto on behalf of Yancheng Shanda. In this case, there is no actual dispute about the makeup of Yancheng Shanda and its partnership.
Forgive me, but I want to ask you right off the bat, what evidence, not allegations, but evidence, is there in the record about the citizenship of the four partners? I looked over the newly filed affidavit, as we all did, and it appears to be heavy on legal conclusions, but not very informative as to facts about citizenship of the partners.
The new affidavit lays out who the four different owners are of Yancheng Shanda, and each of those owners qualifies as a corporation under U.S. law because, in very similar fashion to Biomatic, it meets personhood, limited liability, and the shares can be bought and sold subject to certain restrictions.
What are those restrictions? That seems to be your colleague's point, that the restrictions are so restrictive that this looks like a
Right.
LLC.
So in fact, in InStep Software, a case that my colleague has cited, where it was remanded to the district court, they took a look at a Chinese company, very similar, that had the exact same restrictions as are placed on shareholders here, and found, in fact, that that company was a corporation for purposes of diversity. The fact that there are limitations on the transferability of shares does not matter. It is that shares can be transferred, subject to certain restrictions.
Where in the record are we going to find the ins and outs of exactly what these restrictions are?
They are in the Chinese law itself, Article 71.
Do we have a translation of that in the record?
We do, yes.
Well, the plaintiff faults the defendant for citing no case regarding how to handle diversity jurisdiction when some owners are foreign citizens under 1332A2 and some are a foreign state under 1332A4. Has any court ever addressed this factual scenario? I didn't see any cases on point cited in any of the in your brief either. I mean, I might have missed it. Who knows?
I don't believe that there has been a court which has directly addressed the case of a partnership that includes a plaintiff that is both has partners that are both a foreign state as well as partners that are not a foreign state. Again, you don't need to reach that issue if you determine that the four entities are corporations. However, the changes to 1332, the act giving help to foreign governments, removing them from defendants in diversity jurisdiction cases, to read that act as precluding a partnership between a foreign government and a citizen of that government from diversity jurisdiction would be completely contrary to the purpose of the act. There's simply no basis for saying that. Furthermore, in Page versus Democratic National Committee, the standard was set forth of what's required for diversity jurisdiction, and that is that all plaintiffs are diverse from all defendants, and that each of them fits within one of the categories. Here, you look at the partnership, it has four different partners. All of those partners fit within one of the four categories. One of them, if it's not a corporation, then if you go further down the chain, you find out it is a government entity. And a government entity is not stateless, it is a state. So to say that it's stateless would be contrary to that.
Mr. Giovanetto, I'm sorry, go ahead.
Oh, I'm sorry. No, please.
If we make a determination that subject matter jurisdiction does exist, and we're reviewing the merits and Judge Bruce's determination with regard to the application of the Recognition Act, is there a problem with the way he made inferences on summary judgment for Mr. Kevin Wan? Specifically, I'm thinking of what we have here is a mailing to the last known address, although he's left a month earlier. There's a lot of discussion with regard to the brother, but it turns out, of course, that the subsidiary was in a different province. How is that going to be enough under the standard, under the Illinois Recognition Act, for there to be notice?
Certainly. So the parent company that for which Kevin Wan was the CEO and his brother also worked was housed at a location in China, and that's where notice was sent. His brother still had an office there and still worked there. He had left. He didn't tell anyone he left. And notice was received by his brother, and his brother actually appeared in court. It is certainly, there's no reason for them to assume that Kevin did not receive that notice. If Kevin had taken any affirmative steps to notify that his address had changed based on the address he had provided them in the contract that was in dispute, or provided any forwarding address, when certainly his brother received the same notice, he could have provided a forwarding address and then he would have received it. There was no way for the Chinese court, no reason for them to know the notice had not been received.
Is there anything in the contract that requires Mr. Kevin Wan to give a forwarding address, or if there is a change of address, to notify the parties to the contract?
The contract does not provide for that, but again, under the standards, under all the cases that have examined what is reasonable efforts to provide notice, it does not require there there doesn't need to be an affirmative duty to provide a change of address. That is on the person who notice is sent. If notice is sent to the last known address, that is sufficient.
And which cases are you relying on for that proposition?
So,
Because the reply brief at pages 19 to 20 seems to distinguish Ma. The unpublished decision that exists did not interpret the Illinois Recognition Act. Are you referring to Nahas and Khatib?
yeah, so there's two questions here. One is what is the standard under the Illinois Recognition Act? And then the second is, if the standard is, as we have stated, that the same as due process, that you have to provide reasonable efforts of notice, then you look at all of the due process cases, which includes Ma, as to what is reasonable notice, reasonable attempts to provide notice. And so under those cases, in both Ma, CFTC versus Lakeshore, Al-Kaidi versus Luna, Krochik versus United States, the standard is mailing to the last known address is sufficient unless you have reason to know that the address has changed. Here, Mr. Wan did not tell anyone he had moved. He didn't leave a forwarding address. There was no way for them to know that he had moved. The only thing they point to is the fact that when notice was sent, it was signed for by someone who, it wasn't sure who that was. But again, when you send notice to a large building, it gets signed for, and then it gets delivered. That's how the standard practice is. There'd be no reason for them to think, oh, well, his brother, who was signed for by the same person, received the notice, but he didn't receive it.
Thank you.
Are you, having heard what you've heard so far this morning from your friend, Mr. Sokolov, do you still assert that we must decide subject matter jurisdiction rather than remanding to the district court to address it in the first instance? I myself, and I speak only for myself, I did not see a sufficient factual or evidentiary basis in the record to make that decision on appeal. And given that it is a plaintiff's burden to establish subject matter jurisdiction, are you sure that you want this court to definitively decide it on appeal?
If this court feels like it does not have sufficient information about the makeup of Yangcheng Shanda in order to make a decision of subject matter jurisdiction, the appropriate course would be to ask for supplemental briefing or an additional affidavit. There's no actual dispute about who makes up Yangcheng Shanda. They haven't pointed to any evidence. They don't have any real questions of how the entity is structured. If all that's missing is an additional affidavit because you don't believe that the entities are sufficient as corporations, we can certainly provide an affidavit testifying to what is already in the record in our complaint. Again, that's all the information there is. There's not going to be additional information. We know who all the parties are. We know that one of the four entities is a company that is eventually owned by entities owned by the Chinese government. We know that all the other entities are either owned by other Chinese corporations or individuals who are domiciled and citizens of China. So there's not...
Well, here's the problem, for me at any rate. The plaintiff, it seemed to concede that the court relied on allegations in the complaint rather than evidence in deciding that diversity requirements were met, okay? Now we have this affidavit that purportedly resolves the fact questions, but several of the statements in the affidavit are absolutely legal conclusions. They're not facts. Secondly, the affiant, who is an employee of the partnership entity, is unlikely to have personal knowledge of the citizenship and form of the four partners. Nothing was submitted from the four partners themselves. Isn't all of this a matter that the district court should have an opportunity to sort out in the first instance?
First, I believe, Your Honor, that in a closely held company, it is likely that an employee would know about the ownership of the partners here. Second, again,
likely? Is that good enough here?
Again, all we're missing, or all it seems that you're requesting, is an affidavit from the four partners. I'm not sure what the purpose is to send it to the district court to get that affidavit.
That's only one.
I
portion.
understand, Your Honor.
Yeah, right.
And certainly if you determine that you should remand it for purposes of the district court analyzing this issue, it would not be appropriate to vacate the ruling in that case. In the cases where this is remanded, the only times when it's been vacated, the judgment vacated, is where that judgment was based on a misunderstanding of subject matter jurisdiction, which is not the case here. It was not something that was challenged below, and the district court got it wrong. Here, the district court felt that it had sufficient information on subject matter jurisdiction, and so moved forward with the case. That they didn't think that they were required to have more information in summary judgment because it was not challenged. But if you would prefer to have the affidavit submitted in the district court, we certainly can do that as well. Again, though, if the Chinese companies are corporations, it doesn't matter who their owners are. That information becomes irrelevant because there are 4 corporations. The corporations are all undisputedly domiciled in China. I believe my opponent has suggested that a Chinese corporation cannot be under A2 if it is owned by the Chinese government. However, that only applies if the corporation is a defendant. Under the plain reading of the statute, the corporation is included in A2. Again, the only reason courts have said that a corporation cannot be considered a defendant when it's owned by a foreign government is because foreign governments have rights under 1330 that they cannot be sued in diversity jurisdiction. That does not apply to plaintiffs.
You know, on page 1 of the response brief, the plaintiff identified Yancheng Shanda as a partnership. On page 24, the plaintiff argues that this was an, quote, undisputed fact, end quote, that Yancheng Shanda is a, quote, Chinese company, end quote, a plainly erroneous assumption on which the district court relied to establish citizenship of the plaintiff. Why should we be bound by such a clearly erroneous conclusion?
I believe the conclusion that it's a Chinese company, I'm not sure that the district court was distinguishing between a company and a partnership. But again, in the record, we certainly stated that Yancheng Shanda was a partnership. That I don't believe that issue was ever in dispute.
Mr. Giovanetto, could you distinguish for me these Chinese corporations and what we call an LLC in this country?
Right.
How do we distinguish between the two? If you're an American LLC, then your position would fall. How are they different?
Yeah, so there are, again, the factors that were set forth in Biomatic. First, personhood, that it's a separate legal entity, limited liability, and shares that are bought and sold subject to certain restrictions. In typical U.S. limited liability company, they're not shares, and those shares cannot be bought and sold to third parties, which is the case with the Chinese company.
I see. Okay.
And so it's very similar to the entity in Biomatic, as well as other companies. In Flextronics, there was an identical Hong Kong entity. Again, it's under Hong Kong law rather than Chinese law, but the law was the same. Identical form of company that was found to be a corporation. Similarly, in LearCorp, that's another case where there was a Bermuda limited liability company. Again, very similar in its structure, found to be a corporation. And so that issue is one that I think should be easy for this court to determine.
I think the only difficulty is that Biomatic's fairly laconic. And that's why I asked the question. Really wanted to get into that as best as we could here.
Thank you very much. I see my time has expired.
Thank you.
Now, Mr. Sokoloff, you had asked for 4 minutes of rebuttal. And we asked you an awful lot of questions. So you may have your 4 minutes.
Thank you, Your Honor.
Mr. Sokoloff, could I ask you to begin on the same vein that I asked Mr. Giovannato? If subject matter jurisdiction ends up being established, your thoughts with regard to the district court's handling, and if it ended up in a remand, what would that look like?
Thank you, Your Honor. Yes, I wanted to go there because I think one of the keys here is that Yan Cheng does not and cannot cite a single Illinois case that says that reasonable efforts are sufficient under the statute. And to the contrary, the Illinois Supreme Court has held for 100 years that when it comes to uniform acts, the way to interpret these statutes is to apply them according to their plain and ordinary meaning. The plain and ordinary meaning of to receive notice, especially if you think of it in the context of to receive notice with adequate time to defend, refers to actual notice. And this court recognized that in the Chin case, where it interpreted one of the federal appellate rules, which also spoke of receipt of notice. And here, the district court recognized that there was a genuine dispute as to whether Mr. Wan ever actually received notice. So the court knew that there, and expressly said it could not grant summary judgment if the standard were actual notice. Well, the standard is actual notice, and the court got past that disputed issue only by misreading the statute. If you look at the cases, and I would urge you to read the cases carefully that my friend cites for the proposition that due process is the rule when it comes to the Uniform Act, because actually only 2 of the cases they cite even address this issue. The vast majority of cases in this space are decided basically on 2 grounds. One is that notice is so obviously deficient that it fails due process, and the question of actual notice never comes into play. And that was the case, for example, in the Nahas case, where it was such deficient notice there was no need to explore the specifics. In Khatib, I would note that the court only discussed the Recognition Act arguendo because there was no money judgment there. It was a divorce decree. And so the court started with the Enforcement Act, whether the divorce decree should be enforced in this state, and that is a due process question, not an actual notice question. Notice doesn't play a role there. So there we had the court starting with due process, not deciding that the Money Judgment Act should be interpreted that way. The other cases fall into what I would call the quibbles category. Cases like Galliano, where notice is actually received. In fact, in Galliano it was received 3 times, and the dispute is, well, the notice was in French, or it wasn't stamped with the right stamps, or it wasn't handed to me personally, it was handed to my secretary. That's the Armsco case. The only cases that actually say it's not actual notice, it is due process, are 2 cases out of California interpreting that state's version of the statute. One of them in intermediate California appellate court, the other one a federal district court citing that decision. So there is no binding, and I would say no persuasive authority here that would motivate the court to overlook the plain text of the statute. If I could, Your Honor, I'd like to return to jurisdiction because I think my friend on the other side left you with a couple of points I'd just like to push on further. Judge Ripple, you asked if you could distinguish these entities from U.S. LLCs, and I don't think that he did in his answer to your question, because it's clear that personhood and limited liability are attributes of U.S. LLCs. That was, after all, in Fellows, why this court said, well, if the best you have is corporate personhood, talking about the exact same kind of entities at issue here, then that's plainly not enough to treat you as a corporation. So we come down to the question of alienability of shares. And my friend said, well, the only thing the court means there is if you literally cannot alienate your shares under any circumstances, then maybe you're not a corporation. But if you can under certain circumstances, then you can be treated as a corporation. Well, again, you can alienate shares and membership interests in an LLC subject to certain restrictions. So that's not a distinction from an LLC. If you look at the Delaware law or the Illinois law on LLCs, it's clear both of them have that same feature. The feature that they have is, and I'm sorry, my time has expired, but if I could just briefly finish, the feature that they do have in common with the companies at issue here is that the default rule by statute is extremely restrictive. And here, the default rule, it can be circumvented by the limited liability company's charter, but there's no evidence in the record that the charters here do get around that rule. And so the best we know from this record here with Judge Rovner, I think you hit the nail on the head. It is deficient in this respect. The best we can get to here is that these are entities that have their own legal personhood, limited liability, and sharp restrictions on alienation that makes them decidedly more like LLCs than corporations. There are no further questions.
Judge Ripple or Judge Brennan, do either of you have any more questions?
No, thank you.
No, thank you.
Thank you.
All right, well then, thank you. And thanks to both parties. The case will be taken under advisement. Thank you very much. All Right. So we're going to go on to case number 2. And that case is 22-1194, Brian Orozco versus Cook County. And hello, Miss Nicholas.
Good morning. May it please the court, counsel. This court has twice remanded this case with instructions to the district court to determine what the Cook County Jail's policy is with regard to books and magazines that are seized from inmates pursuant to the jail's 3-book limitations. The district court has twice failed to heed this court's instructions. Instead, the district court made a determination that because Mr. Koger received notice of the jail's 3-book policy and notice of the jail's intention to enforce that policy, he received all the due process that was due before his books were summarily destroyed. This decision was in error because, as this court previously recognized, it improperly conflated 2 distinct interests that Mr. Koger had in his books. First, the possessory interest, which he lost by keeping too many books in his cell, and second, the property interest, which he did not automatically forfeit. This case should be remanded for a 3rd time for a determination of what the jail's policy actually is with regard to property that is otherwise lawful, that is confiscated from inmates pursuant to limitations on the property they may keep in their cell, and a determination of how that policy was applied to Mr. Koger.
This Nicholas, you used the word. Sorry, go ahead, Judge.
Go ahead. No, you.
No, please, you go.
All right. Thank you. Ms. Nicholas, Koger is not, he hasn't responded to the jail's argument that he had no property right in the books under Illinois law. And we typically look to state law to define property rights in the first place. Can you respond to that argument now? Can you distinguish Webb versus Lane?
Well, yes. Under the state law about what constitutes contraband, books do not fall into that category. There are illegal items in which someone would not have an arguable property interest if they were in their cell in the jail. However, books are the type of item wherein a person can forfeit their right to possess those items by having more than the permissible amount in their cell. However, that does not automatically forfeit someone's property interest in those books.
A lot of the dispute then in this case is about the meaning of the word contraband, isn't it? Contraband is used very loosely throughout the proceedings.
That's right, and I think that's the essential core problem with the jail's policies here, which is that they have a policy whereby illegal items and otherwise lawful items that are just in excess of the limits placed by jail policy are both defined as contraband. And a very predictable result of that is that jail officials who are tasked with enforcing these policies will then decide that it's perfectly permissible for them to dispose of those that kind of property when confiscated from inmates, throw it in the trash, or take it home for themselves. And when you've authorized jail officials to enforce a policy like that, it's of course necessary for the jail to have a policy about what should be done when materials are confiscated. It's a very predictable result what happened here.
Now, your client, did he ever avail himself of the remedies or any of the remedies that we know were afforded? Did he ever try to mail these out? Did he ever try to have someone pick them up? Did he ever do anything to help himself out here?
Well, so as far as we know, he did not attempt before the books were confiscated to mail them home first. But there is a reason for that. One, which is that throughout his incarceration in the Cook County Jail, he had every reason to believe he was permitted to keep extra books in his cell, because not only was he permitted to keep 30 to 40 books at all times, so was everyone else around him. Second, once the books were taken away, he didn't have any opportunity to avail himself of that process because all the books were thrown in trash bags and tossed in the garbage.
Of course, there was some kind of notice given that this shakedown was going to take place, right?
Yes, so there is some testimony in the record that some jail officials were walking around the jail perhaps a day or two before this search occurred, saying, hey, we're going to be enforcing this 3-book policy. You might want to think about getting rid of your books. And so that did give Mr. Koger notice that the 3-book policy was going to be enforced. But that's different from authorizing a total deprivation of the books, his property interest in the books, permanently discarding those books, throwing them in the garbage, or the guards taking them home. And I think there's a couple of Supreme Court cases. Well, first I'll start with a case that was cited by defendant, which is Trigg. And there, the question was whether verbal notice of a policy about drug testing was sufficient to then punish the inmate for refusing to take that drug test. And of course, the notice there was sufficient to enforce the policy. So applying that here, it was sufficient to enforce the policy against Mr. Koger. But enforcement of that policy means taking the property away, taking it out of the cell. It does not follow that it was automatically justifiable for guards to then summarily discard that
So
property.
he was willing to take the risk the books might be removed from the cell, but not willing to take the risk that they were going to permanently deprive him of the books.
I think that's exactly right, because of course, when people are booked into the Cook County Jail, they often have property with them. They might have a watch, a wedding ring, their clothes, their phones, their wallets. And of course, the jail doesn't have the right to just say, well, you're being booked into jail, we're going to throw all of that in the garbage.
In fact, the jail handbook talks about those particular items, doesn't it? What to do with the watch and the wallet.
That's right, and the jail has a policy whereby, of course, that property is returned to you upon your release. Now, what the jail doesn't have any clear policy about is what happens to property that is otherwise compliant with the law, things like books, that are confiscated from inmates simply because they have too many of them.
Let me follow up on that because the word policy has been used quite a bit. It strikes me that with regard to the book, the 3-book, that's an express policy if we end up getting to the Monell analysis, correct?
That's right.
With regard to the quote, policy, end quote, with regard to the book destruction, is that, do you assert an implied policy, a gap in the policies? It wouldn't be an express policy, right?
That's exactly right. It's a gap in the policies where a policy was absolutely necessary. Whereas here you have authorized the jail officials to confiscate this property, you need to have something in place that determines what they do after they do that. And what the evidence in the record shows here is that it was very loose and discretionary. Some
Would the jail have refused to deliver any books in excess of 3 to Koger's cell?
You know, that's a very interesting question because, of course, it could have done that if it was
Okay.
going through
It could have done it. So, if so, what did he lose here? Perhaps the senders of the books would have a claim, but if the prison could have lawfully kept him from taking possession of the books in the first place, how can we say it was problematic to deprive him of the books when they realized he had more than allowed?
That's a great question. So the jail's mailroom does have a policy about what happens with property that's mailed to an inmate that they're not allowed to have. And that policy requires them to either store it in the inmate's property to give to them when they leave, or to return it to the sender. So in either of those instances, Mr. Koger would not have lost his property interest in the books. He would have been deprived of the possessory interest, which we all agree would have been appropriate here. He did not have a possessory interest in the books or in having more than 3 books in his cell at any one time. But the property interest was permanently deprived of that. So that's what Mr. Koger lost here. Had the mailroom made the decision not to deliver those additional books to him, he never would have taken possession of the books, so the possessory interest wouldn't have even been at issue. But once he obtained those books, and I'm sorry, Judge.
I wondered if he ever grieved to this issue. I mean, did he file a grievance or anything after the books were taken?
So there's a couple reasons he did not. One is that he was released from jail less than 2 weeks later, and there would not have been sufficient time for the grievance process to even play itself out, even for him to receive a response to the grievance. Two, there was no remedy available to him under the grievance process. The books were already destroyed, they were thrown in the garbage, and compensation for the loss of that property is not an available remedy.
How do we know, though? How do we know the time frame as to when the books were thrown in the garbage or destroyed versus the 2 weeks later when he left the jail?
So there's testimony in the record from another inmate in the same unit of the jail whose books were taken during the same search, that he asked the guards immediately, what happened? Why did you do this? I'd like my materials back, because there were not only books, but also some legal materials that that individual had lost. And that inmate saw that they were all in plastic garbage bags. All of the properties taken from the entire unit, everyone's books, their papers, their magazines were all thrown into trash, 30-gallon trash bags, and were ready to go out. So we know from that there wasn't any remedy available after the books were taken. There was no way to determine whose books were whose. They were all thrown in trash bags, and they were gone by that same day. So in light of that, Mr. Koger really didn't have any remedy under the jail's policies or grievance procedures. So the only remedy he really has is this lawsuit, because he was deprived of due process pursuant to the jail's policy of letting the guards do whatever they want with confiscated property.
Say, letting them do it, but there was a policy of there was a policy of allowing the prisoner to mail these out or have someone pick them up, right?
Prior to their confiscation, yes.
Right.
And of course, that was something that this court knew, and it's even in the court's decision the last time it was here. So if that standing alone was enough, this case never would have been remanded.
I agree that's problematic, but at the same time, doesn't it satisfy the due process clause? That's pre-deprivation due process, it sounds to me.
So I think that it goes back to whether the notice and process was sufficient to enforce the rule prohibiting him from having more than 3 books versus to destroy those books, to permanently deprive him of his property.
Those two are mentioned in the prisoner handbook or are not mentioned in the prisoner handbook? Those two means of getting rid of the books prior to a shakedown.
I believe there is a mailroom policy whereby someone was informed of their ability to obtain envelopes and send items out.
And so he knew about that, and he knew about that or had constructive notice about that. And you're not arguing that anybody impeded him from using that?
It's not, there's really nothing in the record about that one way or the other.
One way or another, okay. I still have a very hard time, and maybe help me out. I mean, that sounds to me like pre-deprivation due process. And that for many of the cases indicate that's even superior to post-deprivation due process.
So I think we have to distinguish which deprivation we're talking about. That was pre-deprivation process for the loss of his possessory interest in the books. But you have to have a pre-deprivation process for destroying the books, permanently depriving him of them.
Pre-deprivation interest in the possessory interest also ensured the protection of his long-term possessory property interest.
See, I think the problem is that it is so open-ended, because of course, pursuant to the policy as it's written, as soon as he had 4 books, the guards were authorized to take at least one away, and there was nothing to stop them from immediately throwing it in the garbage. Now, under this court's decision in Streckenbach, that suggests that some kind of delineated time frame, giving a reasonable, real opportunity for someone to protect their property rights in their property would be appropriate.
So basically what you're saying is, when you're dealing with prison guards, you got to spell it out. And the fact you can't trust the prison guard to infer from the post office department's regulation that they were supposed to do something other than throw this away.
That's exactly right. And this case is the perfect example of why such a policy is necessary. So I see I only have a few seconds left, so I'll reserve the remainder of my time. Thank you.
Thank you.
Thank you. All right. Good morning, Mr. Power. How are you?
Very well, thank you, Judge.
And if Coger had a property interest in the books once they were removed from his cell, what process was in place for Coger to protect that property interest post deprivation? What relief was available in the grievance process, for example?
Well, for example, in the grievance process, and we may be getting a bit outside the record here, but through the grievance process, he could have notified superiors in the jail that his books were taken, and he could have filed a grievance challenging the 3-book rule itself about the search, the impending search that he was given notice of, or after the fact that his books were taken.
That's all.
That would have gone up. I'm sorry?
Please continue your thought, and then I'll stop you.
That would have gone up the chain of command. Frankly, the grievance process is a somewhat fluid process. People could have looked into it. They could have taken appropriate action that they thought might have been necessary. At some level, it also could have. There's a fund within the inmate services where they could have tried to acquire replacement books for Coger. It's not set in stone what the remedy might have been, is the point, that once the grievance got filed, the jail could react to it in various different ways.
So the basic point is that this fellow should have stopped the garbage truck, right? He should have stopped this stuff from, once it was committed to the garbage system, he should have done something to stop it.
Well, I think it's worth repeating, Your Honor, that Coger himself testified that he thought his books were turned into the jail library. Coger's own testimony was not that they were thrown away immediately.
Well,
It was
you
that
see,
they were.
that's what he thought happened. He thought that happened, I gather, because that's what the policy was pre-shakedown. That's what would have happened to his books. He just inferred that these prison guards would have followed that policy. An inference which unfortunately was previously mistaken. The guards weren't going to follow the policy.
Well, Coger actually testified that he heard that from other detainees on the tier. And if I could step back a second, Your Honor, to address a point counsel made in her opening, she faulted the district court, for this issue of not looking into the policy of what the jail's policy is, of how they deal with books after they are confiscated. And there's a reason for that. And the reason is that after this court's second remand to the district court asked the parties for some guidance on what should happen next. And there's a status report in the record at ECF 196. And in the status report, defendants said that there was need for additional discovery on this issue about the due process and the process of what the jail does with books. Plaintiff, however, said, and I quote, "Plaintiff believes the due process claim can and should be resolved on the record as a matter of law. Plaintiff therefore requests that this court set a briefing schedule for summary judgment." And so plaintiff is the one who said, no, we don't need to do more discovery onto exactly what the jail's policy is, and we should decide this issue on the record as it stands now. And so to the extent that there are questions about this, they're not questions of fact, they're just areas where plaintiff has failed to meet his burden in coming forth with evidence to establish exactly what happened.
Why did the prison keep delivering books to his cell after the first 3? Is there any other category of contraband that the jail delivers to the inmate cell? I mean, if someone sent Coger a birthday card containing cash or a pocket knife, what would the prison do with that mail? I mean, if it's contraband, why are they delivering it? Here's your contraband?
Judge, and again, we might be going a bit outside the record, but I think the mailroom reviews mail that comes in. And if it's drugs or a knife or a shank, the contraband will be kept out at that point in the mailroom. But then when it comes to the actual delivery, it's a jail-wide system. It gets funneled out through various divisions, various tiers, then finally to the cells themselves. And so, no, the mailroom does not have someone go to each cell and count up each and every book before it's delivered. So the mailroom would deliver the mail, would set the process in motion for the mail to be delivered, for the books to be delivered. And then once Koger received those books, it's up to Koger to go through the process that's discussed in the briefs to count up how many he has. Again, there's no dispute that the 3-book rule is set forth in the handbook that every detainee has upon arrival at Cook County Jail. Koger was serving a 300-day sentence at Cook County Jail. He knew he was only allowed to have 3 books, but instead he had more than 30. He could have mailed his excess books home. He could have given them to other individuals on the tier. He could have asked a friend to come to the jail and pick them up. Instead, he did nothing. And again, Koger acquired these 30-plus books over the weeks and months before the October 5th, 2013 search. He wasn't, instantaneously out of compliance. He had weeks or months of being out of compliance with the rule, and he took no steps to divest himself of the excess books. And then again, the notice we're talking about is not only the notice in the handbook, but again, we have Koger himself testifying that in the days leading up to the October 5th search, he was again specifically told, hey, you have too many books in your cell. You're going to need to get rid of your excess books.
Look,
Again,
forgive me, but the jail, you cited our opinion, Eckenbach versus Van Dessen, for the proposition that a policy authorizing destruction of inmate property cannot be condemned for authorizing destruction without notice when the policy itself gives notice, which I think is your argument now. But the jail's policy here authorized only confiscation, right? Not destruction. I mean, what notice did inmates have here that their property would not just be confiscated, but would be destroyed if they did not remove it before a search?
Your Honor, I think the notice is one and the same, that a detainee in a prison, a prisoner in a jail, should know that they're not going to get their contraband back. The other items like contraband, shanks, hooch, weapons, detainees should know that if these items are confiscated from them, they're not getting them back. And so that's the notice.
Is a book contraband in the same sense as the items you just mentioned?
So it is and it isn't, Your Honor.
Isn't that the problem in the case?
Well, Your Honor, there's no dispute that Koger had more than 3 books. There's no dispute that he was left with 3 books after the search. So only items that are expressly defined as contraband were taken from Koger. And so while books are clearly contraband, the jail does distinguish between different levels of contraband. There are general orders that the jail can take different steps with regards to certain kinds of contraband. There are internal disciplinary proceedings. Possession of excess books would qualify for a verbal warning, and I think maybe up to 4 days in segregation. Serious weapons, drugs, there are different levels of violations where they would lead to more time in segregation, more disciplinary procedures. Also, the jail reserved the right to refer these cases to the state's attorney for criminal prosecution. So while both are contraband, the jail is able to distinguish the levels between the different kinds of contraband.
Aren't you ignoring Judge Easterbrook's earlier opinions about property versus possessory interest?
No, Your Honor, and Judge Easterbrook said that just because a plaintiff lost a possessory interest in the books by keeping too many in his cell, he didn't automatically lose his property interest. And he also said that books are property, but he didn't say that Koger had a property interest in those books. And again, just because while he may have not have automatically lost his property interest by losing his possessory interest, again, he never had that property interest to begin with. And that's the discussion here with under Webb, under controlling Illinois law, as Your Honor alluded to earlier, detainees in a prison setting don't have a property interest in contraband. And these due process issues, this question of whether or not detainees have a property interest in contraband to begin with, was not addressed by this court. The procedural history of this case is rather winding, but what came before the court was whether or not plaintiff could even bring a due process claim. And what this court ruled on previously, what Judge Easterbrook ruled on, was that the possessory interest and the property interest are different things, and so the due process point had to be remanded back. And the first step in that due process analysis is whether or not Cogar even had a protected property interest to begin with. And when it comes to property interests, we look to state law. And the controlling state law here is Webb, which says that no, courts can look to criminal statutes as well as prison regulations, prison's rules and regulations to define things as contraband. And if something's legitimately defined as contraband, then no, prisoners don't have a protected property interest in them. And Judge Easterbrook said, just because an official says something is contraband, that doesn't make it contraband. And that's absolutely true. We'd agree with that. And in the Webb case, the court did a Turner analysis. And that's precisely the analysis that this court did in plaintiff's prior appeal. And looking through the Turner factors, the court in Webb found that the excess currency that the detainee had in his cell was appropriately called contraband, even though money is not generally contraband. Money is not dangerous. And that's what this court did previously, that yes, you and I might like to read books. A lot of people use books in legitimate ways, but there are legitimate concerns in a jail setting about ways.
Forgive me for a minute because I'm having a problem. When the jail accepted and delivered his mail, he had a property interest, right? I mean, and what about the first 3 books? He had a property interest in those, but nothing was distinguished when they threw them away. They just threw them away. I mean, presumably he had a property interest in the first 3 books he received.
Well, at all times, his property interest was confined by the rules of the jail. When he only had 3, he would have had a property interest in 3. When he had more than that, though, it's any 3. And plaintiff was left with 3. We all agree that plaintiff was left with 3 books.
Yeah, but where does it say any 3? Not maybe the first 3 were really important to him, like his Bible, his mother's memoirs, heaven only knows what.
Correct, Your Honor. And if there were 3 books that plaintiff found to be especially important to him, he could have protected those 3 by getting rid of the excess. He could have mailed the excess home. He could have given them to other detainees on the tier. He could have simply thrown them out and gotten rid of them. And in that way, he would have protected the 3 that he wanted to keep. And so when the officials showed up at his cell on October 5th to conduct the search, they would have seen he only had 3 books. They would have left him with 3 books. Everything would have been fine. And so, on that front, he was not deprived of more than 3 books. He was left with 3 books after the search. And then finally, Your Honor, with time running out, turning to the third point, the question of municipal liability. And plaintiff just admitted that there's no evidence of an express policy authorizing the destruction of these books, which means that they need to come forward with additional evidence of other times when books were summarily destroyed. And that's simply not in the record. And again, as stated earlier, in that status report filed at docket entry 196, plaintiff had the opportunity to develop the record on this issue, and plaintiff chose not to do so. Plaintiff wanted the case decided on the record as it stood at that time. And as this court recently decided in Bohannon v. Indianapolis, with the opinion just issued about a month ago on August 22nd, Inaction only constitutes a policy if there's evidence of a conscious decision not to take action. Plaintiff has put forward no evidence of a conscious decision not to take no action. And when it comes to a gaps in policy claim, a gaps in policy amounts to municipal action for Monell purposes only if the municipality has noticed that its program will cause a constitutional violation, and typically notice is established by a prior pattern of similar constitutional violations. Again, plaintiff has put forward no evidence of other times when books were taken pursuant to the 3-book rule and then summarily destroyed. Seeing that I'm out of time, if there are no further questions, we ask that you affirm the district court. Thank you.
Thank you. Okay, Ms. Nicholas.
Thank you.
You asked 3 minutes, and we'll give you your 3 minutes.
I appreciate that. Thank you. I'd like to just respond to 3 points made by counsel in his argument. First, with regard to his citation to Bohannon, I think in that case, this court identified cases where a gap in policy could amount to a municipal policy that could give rise to liability. And that's where, as here, the need for a policy is so obvious that the failure to have one amounts to deliberate indifference to constitutional rights. This is precisely that type of situation. The jail has authorized its officials to deprive inmates of property in excess of the amounts permitted by the handbook, and not having a policy about what happens to that property when it's confiscated is naturally and obviously going to result in permanent deprivations of that property without due process. Second, it seems to be counsel's argument that Mr. Cogar could have protected his property interest in the books by simply complying with the 3-book rule. Of course, you could say that in any due process case. For example, in Venice versus Michigan, the person could have avoided loss of their vehicle by not allowing it to be used in the transport of drugs. In this court's decision in Miller, Mr. Miller could have protected his interest in his guns by not abetting other felons in having possession of guns. Or in Jones versus Flowers, somebody could have protected their home from being sold in a tax forfeiture by paying their taxes. That doesn't relieve the state of its obligation to provide due process when it seeks to deprive someone of their property permanently. Due process is still required before that permanent deprivation occurs. And then finally, with regard to whether state law would have defined these books as contraband such that it was appropriate to permanently deprive Mr. Cogar of his books without any further process, this court cited in its decision the Illinois statute that defines what is contraband under Illinois law, and books are not included on that list. Therefore, it is not appropriate to automatically designate books as contraband in which Mr. Cogar had no protectable property interest. So for all of those reasons, we ask that this case be reversed and remanded for the reasons set forth in our briefing. Thank you.
Thank you.
Oh, my goodness. Thank you both. The case will be taken under advisement. And the court's going to take a 10-minute recess. Thank you all. Thank you, everyone. We're going on to case number 3, and that case is 22-1168, United States Bank Trust National Association versus Walworth County, Wisconsin. And it's Mr. Dan. Good morning. Good morning.
Good morning, Your Honor. May it please the court, my name is Mark Dan. I represent U.S. Bank as trustee in this matter. We are the appellant. The facts in the case are not in dispute. The most important distinction today is that this case is not about due process of law. This case is about the takings clause of the U.S. Constitution. I'm
going to start you right off because the bank argues that there was no mechanism in which a lien holder could recoup the excess value of the forfeited property. But the bank could have redeemed the entire property early on in the process by simply paying the taxes owed during that 8-week redemption period. And it appears that there was also a second opportunity to reclaim the property during a repurchase period before the county completed a sale to a third party. So my question is this: was the entire problem caused by the bank's inaction?
Your Honor, I agree with your analysis of what happened. However, I believe the bank could have done a number of things along the way that would have mitigated its own problems. However, I think it's irrelevant. That analysis is irrelevant to this case and to this determination. The taking, as pursuant to Article 5, or I'm sorry, to the Fifth Amendment to the Constitution, did not take place. There were two takings really. One was the taking of the right of the lien, the right to collect the mortgage payment that was taken at the first foreclosure hearing, and then the second time was when the property was alienated by the county, and they received proceeds that exceeded the amount of the taxes impositions that were due. The fact that U.S. Bank didn't avail itself of the due process opportunities that it had is irrelevant to the analysis of whether or not A, that there was a taking, and B, because it's undisputed that the property sold for about $13,000 more than the tax impositions that were owed to the county of Walworth. So the taking took place, and again, 2 times, because by the time that the property was sold, because of the foreclosure that that U.S. Bank was conducting, the property was actually entitled to U.S. Bank at the time that the final decision was made to transfer title to Walworth, which then auctioned the property off to somebody else. But it was not clear that there was a taking of property until the property sold for more than the amount of the amount that was due. The Bill of Rights, Your Honors, is not a buffet of offerings where a citizen can only take one. Each exists independently of the other. The existence of extensive due process cannot relieve the government of its obligation to compensate under the Fifth Amendment. Now, the district court relied on 2 cases, and there's a third case that was decided after the district court's decision that I'd like to address because they're kind of the centerpiece of our of the county's brief. The first is Nelson versus City of New York, which is a U.S. Supreme Court decision. And I just wanted to make sure the court understands how that is distinguishable from the circumstances in this case. In the New York case, there was a mechanism post-taking for owners of property to recover the funds that were available to them. So once the taking was completed, there existed a process under New York law where the taxpayer could seek from it was the City of New York, seek from the City of New York the amount that they collected in the sale beyond the amount of taxes that were owed. Wisconsin has no similar mechanism. So post-taking, whether it be the taking at the time of the lien interest, or the taking at the time of the property interest when the property was sold for more than the taxes were due, after those points, there was no mechanism for U.S. Bank to approach it. There's a footnote in the brief. There is a mechanism if there is a mistake of law or fact to raise that issue, almost like on a standard of a motion to vacate a judgment. But there's not.
Forgive me, but I don't think what you're saying is correct. Look, you could have paid the taxes and redeemed the property as soon as you were notified of the problem. Again, you could have answered the in rem petition and you didn't. The silence, the inaction, results in a default judgment that gives or gave the county a fee simple absolute in the land. At that point, of course, the county could sell the land, but the statute gave the owners a second chance at that point. If you would have received an amended judgment removing the property from the in rem, and the land would have been reconveyed to the bank. But you took no steps to protect your interests when the county sold the property. So the surplus belonged to the county, and the bank no longer owned the property. So what was there left to take? I mean, I'm really having some difficulty here.
And I understand, Your Honor. However, what was left to take, there was nothing to take. If the county had kept the property, and the property's value was the same or less than the imposition of taxes, then there would have been no taking. Notwithstanding the fact that the bank sat on its rights exactly the way that you described it, Judge Rovner. I'm not living in an alternate universe. But the fact is that the taking didn't occur until there was more money paid to the county. Everybody owes the government its due, but just its due. It is inequitable, and the reason that the takings clause exists and has existed in common law going back to Magna Carta is because it is unfair to impose a burden of additional taxes on a party just because the state legislature created a mechanism that didn't provide them with an opportunity to get the difference at the time of the actual taking.
Even if the party had two opportunities, does nothing, just sits there.
I understand, and when I first started to look at these cases, Your Honor, I had the exact same reaction. The problem is the taking doesn't occur until the county receives more than the impositions of taxes. Up until that point, there's no taking. And at that point, there is no mechanism for the taxpayer to collect the rest.
So we should say to the Wisconsin, we should thumb our nose at the Wisconsin courts, which have rejected the claim that property owners have such a right to the surplus when a county has followed the tax sale procedure. I mean, property rights are determined by state law, and it seems to me at this point that our court would be bound by that reading of the law.
Your Honor, I think you're referring to the Ritter decision from the Wisconsin Supreme Court that addressed this issue. But again, that analysis was exactly the same as the district court's analysis. It focused solely on the due process argument. It didn't focus at all on the issue of the taking and the lack of a remedy post-taking. And so it is our contention that they got it wrong.
So bottom line, we're not bound by the Wisconsin court's own interpretation of the property interest in the Ritter case, right?
But certainly
Right.
this court isn't bound by their interpretation of the U.S. Constitution, or necessarily bound by their interpretation of certainly of the U.S. constitutional claim here, which exists. The Seventh Circuit can certainly take a different position on whether it's good, whether even though there's immense due process, that when a taking takes place, that a citizen who ends up, or a corporate citizen in this case, who ends up paying more than their fair share, is entitled to get that refunded to them.
And would we have to create a circuit? I'm sorry. Well, would we have to create a circuit split with the Eighth Circuit's decision in Tyler?
Yes, and I think it's important, and I know I'm into my rebuttal time, but I'll do my best to address this. The Eighth Circuit, since this decision was issued Tyler versus Hennepin County. There's an important difference between the Hennepin County case and this Walworth County case, because Minnesota affirmatively eliminated common law when it incorporated as a state. Wisconsin actually enshrined common law in its constitution. Article 14, Section 13 of the Wisconsin Constitution preserved the English common law in the state. And that's been upheld multiple times by the Wisconsin Supreme Court. So this case is distinguished because the property right that existed didn't exist in Minnesota because it was a common law property right, absolutely exists in Wisconsin. And that's the property right that was taken pursuant to this agreement. The equity in the property, including the difference between the taxes due and the actual value, has always been recognized as a property right under common law in Wisconsin law.
Mr. Dan, it seems to me what you're really complaining about is the Wisconsin state court judgment here. And I'm wondering why you're not barred by the Rooker-Feldman doctrine. You're really asking us to review the decision of the Wisconsin court, aren't you?
No, Your Honor. This decision was not. This case had never been before the Wisconsin Supreme Court.
I understand that, but aren't you in effect asking us to take a position different than the Wisconsin court?
Well, there's been a change since that Wisconsin court decision occurred, and that was in the Nick decision from the U.S. Supreme Court. In the Nick decision, it was Nick versus Township of Scott, Pennsylvania. In that case, the Supreme Court held that one may bring a federal claim for just compensation in federal court, notwithstanding the existence of a state law procedure that will eventually result in just compensation. That was in 2019.
The way I read Nick is that it does nothing more than relieve a party of filing suit in state court before bringing a federal action under the takings clause. I mean, I don't know how that would.
Well, that's what we did. Your Honor, that's what we did here. We're not asking for you to revisit our case or a case that was decided. This is a case of first impression in the Seventh Circuit. And there are other jurisdictions, of course, in the Seventh Circuit as well.
But if I recall the brief properly, I think what you were trying to say about Nick was that it somehow silently overruled Nelson. I mean,
well, it didn't overrule Nelson directly. The part of Nelson that addresses the issue of whether or not compensation can be sought relies on the fact that New York had a post-taking remedy for the property owner to recover their damages. What Nelson says is that you can bring a claim whether or not there's such a right. Whatever the status of Nelson, however, it does not control this case because it no longer it doesn't apply. First of all, to a state where there's no post-taking mechanism for taking the property. I'll reserve the little bit of time that I have left for rebuttal. That's all right.
Thank you very much. Ms. Schultz?
Good morning, Your Honors. May it please the Court. S.D. Schultz, Deputy Corporation Counsel, on behalf of the defendants, appellees, Walworth County, and Valerie Etzel as Treasurer for Walworth County. U.S. Bank has no property interest in surplus proceeds of the takings clause of either the U.S. or Wisconsin constitutions can protect. Rather, Wisconsin's former in rem property tax forfeiture law at issue in this case, which I'll refer to as an in rem proceeding, allowed Walworth County to lawfully retain the surplus proceeds. And this process is constitutional for 3 reasons. First, government can enforce property tax collection through property forfeiture as long as notice and due process is afforded within the proceeding. As outlined by Judge Rover in the appellant's argument, U.S. Bank had notice. They had opportunity to avoid the judgment.
In the earlier state proceeding.
Correct. In the 2019 in rem proceeding, they had certified mail notice of, well, first of all, as mortgagee, they should have known that that property was under a tax certificate for 2 years. That could have given them time to timely foreclose on their mortgage at that time.
So,
Then, once the in rem proceeding was filed 2 years later, they received certified mail notice explaining the redemption period of 8 weeks. There's also by statute a 30-day answer period. And then, had it not dismissed its own mortgage foreclosure that was running parallel to this matter, it could have been deemed the owner and then subject to the repurchase opportunity also that the Wisconsin statute affords.
so when the Wisconsin proceedings were finished, the bank was a dead duck. That's your position, right? Their property interest was extinguished
That's correct.
by
And-
operation of the Wisconsin judgment.
Yes, and that's my second point on the constitutionality, that Wisconsin law unequivocally extinguishes a former owner and lien holder's interests at the time of that default judgment. And I highlight the term default because it's their inaction in the proceeding,
So-
their inactivity that led to the
If
default.
that is correct, why wouldn't the Rooker-Feldman doctrine apply? Aren't they really asking us to review the failure of the Wisconsin courts to recognize what they think is a continuing property interest in this land?
I agree with you. I think the Ritter v. Ross decision is dispositive of U.S. Bank's claim. However, because there wasn't a specific judgment in the appellate courts, I considered whether or not to raise that as an issue, but decided not to because they're bringing that constitutional claim under the U.S. Constitution and not simply the Wisconsin Constitution.
That's what they're trying to do. But the fact of the matter is they could have raised that earlier, could they have not?
They could have raised what, Your Honor?
They could have raised their federal issue in the state proceeding by entering the state proceeding.
They could have raised, well, there's an enumerated defense in the in rem procedure. Those enumerations include that the property wasn't subject to the tax, or that the tax was paid but somehow was administratively not applied, or that there was some sort of fraud or duress. So it doesn't really outline that specific opportunity to challenge constitutionality within the in rem
The
proceeding.
proceeding is in the state court of general jurisdiction?
Yes, it was in the circuit court.
Well, certainly that court can't enter a judgment contrary to the Constitution of the United States.
Yes, so I deem U.S. Bank's claim to be a constitutional challenge that's post-collection. They're not asking to reopen the judgment. They're not asking the court to change the amount of taxes that are owed or challenge that tax due. They're asking for that post-collection remedy, which I think is what allows the U.S. Bank to bring it before this court. And that was outlined in Nick to some extent, clearly stating that a takings claim can be brought in a federal court without exhausting state remedies. But also there's been a distinction in other federal courts as well. For example, the Minnesota case, Tyler v. Hennepin County, it started in state court and they asked to remove it to federal court, again, because they were challenging that post-collection remedy. And I saw that as what U.S. Bank was
That's
attempting
been
to do
pretty
here.
common, though, in the country. Some courts seem to be sensitive to Rooker, some courts don't.
Yeah, the Wisconsin statute is silent as to the distribution of surplus proceeds, or the one at issue in this case was.
Ms. Stoltz, with regard to the Rosen case, Wisconsin Court of Appeals, 1988, does that suggest that there's a common law interest in these sale proceeds? And if it does, was that abrogated by the Ritter case?
I'm not familiar with the Rosen case that you cite to, but I do believe
Cited in
that,
the reply brief. It was cited in the reply brief at pages 5 to 6.
I know that the Wisconsin Constitution specifically says that the legislature can abrogate common law. And that's what the legislature has done in this case, even if there's a slight argument that there was a common law interest, but I don't believe that there was one. And the Wisconsin Constitution specifically allows for that abrogation of the common law by the legislature in, I believe it's Article 14, Section 13, that says the legislature can define or redefine the common law. But third, as to the constitutionality here, since the county was the lawful owner at the time the surplus proceeds became available, and this was several months after that default judgment in the proceeding, nothing's been taken from U.S. Bank because their lien was extinguished at the time of default judgment. It's really asking the taxpayers to finish its foreclosure for it and then still get the check in the mail. And I'm asking this court not to reward U.S. Bank's negligence. And Wisconsin isn't alone in this policy decision by the legislature to not provide a mechanism for former owners to request surplus. States like Arizona, Oregon, Nebraska, and Minnesota, they have similar property tax forfeiture statutes, as well as municipalities such as Boston, Auburn, Suffolk, and New York, and these were all challenged in either state court or federal court and deemed constitutional. And what these cases tell us altogether is that states are free to determine what happens with surplus after a tax forfeiture, if and when that surplus arises. It's important to note that surplus doesn't always arise, as long as that due process is afforded in the
To
proceeding.
your knowledge, sorry, I didn't. You see, if you take a breath, I jump in.
I apologize, Your Honor.
No, I apologize. Go ahead, just go ahead.
I ask this court to continue to defer to Wisconsin law in this area, as this is an exercise of the taxing power, and it doesn't violate the Constitution because it follows what Nelson requires, which is notice of the amount owing and an opportunity to avoid the default judgment. And I'm asking this court instead to follow the holding in the neighboring Eighth Circuit, not to create that circuit split that was identified in the appellant's argument. I ask you to follow that because that court provided excellent verbiage, and I'll repeat it for this court. The existence or non-existence of a mechanism to claim that surplus is a modest factual difference, and it's immaterial. And other district courts in Arizona and Oregon have also said that a mechanism to request the surplus doesn't change the analysis because the analysis is about due process. So when U.S. Bank argues that this case isn't about due process, they're ignoring that Nelson decision because that Nelson decision from the Supreme Court merges these two. If there's one, you can't allege a taking. Your Honor, I do believe the Wisconsin law also appropriately balances the competing interests of property owners with the government's needs to levy taxes for the government services that are properly owing.
Ms. Schultz, could you speak at that? Or this, I think, would be an opportune time. For a moment, could you explain the legislative changes that have taken place in Wisconsin?
Yes. In 2021, the legislature did change Wisconsin's law. It now requires that if there is any surplus, that it be sent to the former owner. It doesn't even require that the former owner respond in any way to requested surplus. The treasurer now has to send it out. It also mentions the opportunity for lien holders to access some of that surplus. However, that really hasn't been decided because it talks about liens in existence at the time of the sale. But it's our position that at the time of default judgment, all of those liens are extinguished. So that's a matter that needs to get sorted out. But for this court's analysis, I don't think that the new law is relevant. Apart from the clear deference and policy decision that the legislature has. They represent the will of the people, and the will of the people wanted to change the law, and that's what's happened.
Under the new law, then, what happens to the tax delinquencies if the proceeds, presumably any proceeds sent to the former owner, the tax delinquencies or any other liens on the property have been resolved? Is that correct?
That's correct. That I interpret the law still in existence because the new law only dealt with the surplus proceeds. It didn't actually impact 75.521. But I read the law to say that in exchange for the property taxes that are owed, the county receives that property. There is no lingering balance on that property. There's no remaining delinquent taxes. It ends up being an administrative financial adjustment later, but there's at that point in time that title is cleared. The tax liens are extinguished, and it's in line as well with an attorney general opinion that even declared that a state income tax lien was extinguished at the time of that default judgment.
Is that the one from 1973?
Yes. So I am asking that the court follow the Oosterwijk decision in Wisconsin also. That was 10 years after the Nelson decision, and it brought up the issue of equity. And so, although U.S. Bank may allege that this law is unfair, the Wisconsin Supreme Court has already said that there is no equitable value that that the former owner has on the property after this judgment. And Oosterwijk really does dictate what is the common law in Wisconsin, and this court should follow that. It is bound by the way that Wisconsin defines the property interests in this matter. So unless the court has additional questions, I ask that you affirm the district court's dismissal of U.S. Bank's claim. Thank you.
Thank you, Ms. Schultz.
Thank you. Here's Mr. Dan. Mr. Dan, all right, we'll give you your 5 minutes.
I appreciate. I'll try not to take all of it because I know it's been
That would be wonderful.
it's a long morning, and I appreciate that. I want to just raise a few points in rebuttal. This goes beyond tax collection. This is our claim has zero to do with tax collection. Our claim has to do with what the Wisconsin legislature decided to do, exactly what the Wisconsin legislature did in 2021, which is pass a statute that is consistent with the Constitution and stops the taking of property from taxpayers who end up in a tax foreclosure. But when the value of the property that was taken summarily exceeds the amount of the imposition of taxes.
But you raised the constitutional issue, forgive me, in state court.
I'm sorry, we did not, I don't think we could have, no. The taking didn't occur until the property, 2 points in our view. The first taking of the lien right was when the judgment issued at the end of the state court foreclosure proceeding. Then the right to the lien on the proceeds was taken. However, the U.S. Bank completed its foreclosure in the interim period of time and was the owner of the property at the time the final judgment entry took place. At that point, but even at that point, the taking didn't take place because there was no evidence that the value of the property exceeded the tax impositions. It was only when the county sold the property for more than the tax impositions that taking took effect. And this is slightly different than the arguments that were made in the Ritter case, addressing Judge Ripple's concerns about Rooker-Feldman. And just to be clear, those were different parties at a different place in time, and certainly not. We would not be here trying to ask this court to appeal or to rule on an appeal of a state court judgment. The owners have a discrete property interest in the equity. The county cannot take it without triggering the constitutional requirement that it pay just compensation. And Supreme Court addressed this issue in Horn versus Department of Agriculture. The government can't transform property into public property without compensation, and that's also a U.S. Supreme Court precedent in Fabulous Pharmacies versus Beckwith, which I believe the Seventh Circuit has recognized. States effectively, when they recharacterize traditional private property as public property, which is what the Wisconsin legislature did in the pre-2001 statute, they can't avoid the obligation to pay just compensation. Just because the legislature says it's public property doesn't make it public property, because the constitutional protection against the taking it only attaches at the time the county essentially gets a windfall.
Was Ritter wrongly decided?
I think Ritter was wrongly decided, but I didn't litigate that case, so I don't have all the details of what was in front of the court. But the Constitution clearly allows. The Fifth Amendment was designed to prevent certain individuals and citizens and corporations from paying more than the amount of taxes that they have due. The confusion between due process and takings is easy to make, because there was, as Judge Rovner pointed out, there was a lot of due process that went on, and the equities make this seem a little bit uncomfortable, I'm sure. However, that doesn't abrogate the obligation of the state to compensate its citizens when they take something that they're not entitled to. The state was entitled to the taxes. The state was not entitled to $33,000. They were entitled to $12,000 and change at the time and that money went into the coffers of Walworth County, and it was a amount of value that was belonged to the property owner, and at the time it was U.S. Bank. If there are no further questions, I ask the court to reverse and remand to the district court for further proceedings. And I see I did take all my time, so I apologize.
Thank you. We appreciate the help from both parties, and the case will be taken under advisement. And we're going to go on to case number 4. And that case is 21-2587, United States versus Christopher Ramirez. Hello.
Good morning, Your Honors, and may it please the court. Adam Stevenson on behalf of Christopher Ramirez. Mr. Ramirez's case raises 2 issues relating to his sentencing. First, his designation as a career offender using controlled substance offenses as prior predicates. And second, the district court's failure to meaningfully consider his primary argument in mitigation. With regard to that first issue, the career offender issue, the matter directly involves this court's case in Ruth, which indicated that the controlled substance offense definition within the guidelines, specifically 4B1.2, was not limited to the Federal Controlled Substances Act, but rather any substance controlled by state law. To the degree that Ruth remains binding law and applicable law, Mr. Ramirez's career offender designation is inappropriate. However, this court has set out factors in Buchmeier that indicate when it is appropriate to reconsider a prior case such as Ruth. For example, when the case is an outlier, when reconsideration would save work for Congress or the Supreme Court, or when the prevailing doctrine would create substantial injury. Mr. Ramirez feels that Ruth actually fits all three, and I'll address each in turn. With regard to the nature of Ruth as an outlier, Ruth itself actually indicated and recognized that there was an existing split on this issue. The Second and Ninth Circuits had determined that the definition was limited by the Federal Controlled Substances Act, whereas the 6th and 11th at the time, while internally inconsistent, appeared to potentially allow for an expanded view of the definition. However,
a few more circuits followed us after Ruth. Now I guess the split is almost even, right?
It is approaching even, yes, Your Honor. The 4th, 8th, and 10th circuits have joined this court. But notably, in each of those, whether it be in the panel opinion or in matters relating to en banc rehearing, there were strong dissents that specifically raised concerns that were addressed in the Second Circuit in Townsend and the Ninth Circuit in Leal Vega, as well as in the First Circuit, which has not definitively ruled on the matter yet, but has strongly indicated that in Croco that there were significant concerns about a plain language-based approach. And that is
only the Supreme Court, it seems to me, or the Sentencing Commission can fix the split.
That is one route in which the split could be fixed, and Justices Sotomayor and Coney Barrett indicated such in their statement relating to the denial of petition for certiorari in Garant. There are some practical limitations, however, though, with regard to the Commission's ability to remedy the problem, especially for individuals like Mr. Ramirez. In terms of the Supreme Court's concern in Garant that the Commission did not have a quorum, that has now been resolved. However, the Commission has indicated that for the 22-23 amendment cycle, their focus will be on the implementation of the First Step Act. Many problems have arisen as a result of implementing that act and the guidelines interplay. There's also a significant backlog of potential amendments or policy concerns to be addressed. And last but not least, most amendments, in fact, only 30 of 813 amendments have been made retroactive.
Stash House.